Good afternoon, Your Honor. Good afternoon, Dr. Von Gernert.
Good afternoon.
Now, before lunch, Doctor, we finished chapter 3, and you made the point of saying that chapter 4 took us to really the next time period in your report, that being Confederation. Can I ask you to turn up chapter 4? The slides begin at page 55, slide 55. And here you introduce us to a new character in the play, to use your analogy earlier, John Langton. Can you tell us who he is, please?
He was the new auditor, or I should say the first auditor that Canada had after Confederation.
Okay, and what was his role immediately after Confederation?
Well, he had a number of different responsibilities, but the one that took up most of his attention was his efforts to address all of the complications on the financial side that resulted from the Union and Confederation. And so there are many issues still arising on these in order to settle the accounts as to who would be responsible for paying what as Canada became a dominion and included not just the old provinces, but also other provinces as well. And so he began identifying items that were potentially in dispute in terms of who owed what. And these included the Indian annuities, as they were referred to. And Langdon was of the view that not only the earlier Upper Canada or the pre-1850 treaties and their annuities, as well as the so-called New Indian annuities, which were payable under the Robinson treaties, should be capitalized, because that was the easiest way to calculate what was to be allocated as a expense or liability when it came to settling the accounts that were required as a consequence of Confederation.
And if I can pause you there for a moment, was Langton doing this because there was a change in how these were being paid?
No, these are not being paid any differently than before. They're still all coming from the Consolidated Revenue Fund, but now it's Canada's Consolidated Revenue Fund as opposed to the old province of Canada.
Okay. And just for a point of clarification, I'm sure most of us have it here in our heads, but you said that there was a new dominion with Canada and the provinces at the second bullet point on your slide here.
Yes.
And we've heard, of course, about the United Province of Canada, but you suggested that there were others. What accounts was Langton looking at?
Well, I mean, the ones that were at issue here involve the provinces, the new provinces of Ontario and Quebec. Of course, Canada as a dominion included more than just the provinces of Ontario and Quebec, but it was the old Upper and Lower Canada, or Canada West and Canada East, as they were also called, or the United Province of Canada, that was really at issue, because they're the ones that had specifically the Upper Canada had all these annuity payments. Lower Canada, as I suggested earlier, also had an amount of 4,000 for the Lower Canada Indians. So all of this had to be sorted out. So what was being sorted out really was what liabilities did the old provinces of Canada, or the old province of Canada, have in respect to the new Dominion. And of course, the successors to the old province of Canada were Ontario and Quebec. And so this was really an issue between Canada and the two provinces of Ontario and Quebec.
Could I just go back to one of your points? You said, I think, Ms. Barclay, your question was, did it come from was there a change in the way it was paid? And the answer was, it's still coming from the Consolidated Revenue Fund. Then you said of Canada.
Yes.
Canada post-Confederation,
Yes.
Federal Canada. Thank you.
What you sometimes refer to as the Dominion, as I understand it, is right.
Yes.
Thank you.
So then can you take us through, please, what you describe as Langton's proposal in your slide?
So Langton did the math. You may recall that the earlier interest rates that were always referred to in the province of Upper Canada documentation was 6%. But Langton, and I don't know the reason behind this, frankly, why it's 5% now instead of 6%. That's the amount that he used to calculate what kind of capitalization would be required in order to pay the obligations. And he came up with a figure of 88,000 for the Robinson treaties, as you'll see on the next page.
This is Langton's, this figure is Langton's, not
Yes.
yours, yes?
Yeah,
Can you
so
take us
this,
through this?
yeah, so as you see on this slide, this is Langton's February 1869 statement. And it's showing, I simply reproduced it from the original document. So it's not, I mean, it's a scan of the original. So it shows the capitalization of 5% of certain annual payments secured by the legislation of the late provinces, which are to be charged against them as part of their debt. That's how he understood it, or at least that's how he proposed it. So you see under the province of Canada, by which is meant the United Province of Canada, including Ontario and Quebec. You see there are three different line items. There are the Indian annuities under civil list. And you remember, last, I guess it was yesterday, when I was talking about the civil list, that was an actual statute in 1846. It was the Act for Granting a Civil List to Her Majesty. And that had cited amount of 6,666. And you may remember that that was a misprint, that the actual amount was 6,655. But Langton didn't know that. So he just converted that to dollars, and it was 26,664, which is not the actual amount of Indian annuity. It's off by a few dollars because of that misprint.
And those were the ones that I think you and Her Honor agreed to describe yesterday as the pre-1850
Yes,
treaty annuities? Is that
that's
right?
correct.
Okay, and what else do we see here?
Then in the second item, you see LC 14 and 50 Vic Cap 106. was another statute, and I explain that one in some detail at footnote 331 of my report. In brief, what that was is that was the $4,000 grant that was given annually for the Lower Canada Indians, as they said, who would have been, as I said earlier, Ganawaki, Kanesatake, and the others who lived in the province of Quebec, but received no annuities at all because they had no treaties. And then the third item, UC, which stands for Upper Canada, annual vote. You remember that the Robinson treaties were paid for from the Consolidated Revenue Fund of the province of Canada by an annual vote that provided for the 4,400 for both the RST and RHT combined. And so that was capitalized at 88,000. And then you see,
Collectively for both Robinson treaties.
that's correct.
So can you remind me who this chart purports to show whose debt?
Yeah, Langdon was of the view that this 88,000 capitalization would be charged against the late provinces, which by his time had become Ontario and Quebec.
But he's calling them here Lower Canada, Upper Canada.
That's right.
And is that the point you make at the bottom of slide 55? Does that correspond with that 88,000 there?
Yes. So the auditor proposed that this amount be charged against the old province of Canada, since succeeded by Ontario and Quebec, as part of its pre-Confederation debt.
So it goes into Confederation with a debt.
Yes, it gets a little more complicated than that, as I'll explain shortly.
Is there anything else you want to tell us about slide 56?
No, unless there are any other questions. So just keep in mind that 26,664 should actually be 26,620, because all of the Indian Affairs records show the actual amount, whereas this is derived from the misprinted statute of 1846.
All right, and then what became of Langton's proposal? I think you go through this starting at slide 57.
Yeah, so the proposal, to the extent that it was capitalized, was accepted. And immediately it was reflected in the books that the Indian Department had, and also in the Receiver General's books. So the 88,000, which was drawn, I should say that prior to Confederation, the CRF that I was referring to was the United Province of Canada, CRF. After Confederation, the annuities are drawn from the equivalent CRF of the Dominion of Canada. Right. So the capitalization is also drawn from the CRF and was then split so that 48,000 would go to the RHT account and 40,000 would go to the RST account.
But it's not a credit, it's a debt. It's a debt against the CRF?
No, it's actually drawn from the CRF and given to the Receiver General to add to the annuity funds of the respective First Nations. So it ends up in the, remember,
So let's just see, it's drawn from the Dominion of Canada, or is it
Yes.
of Canada CRF?
Yes,
And it's given to the Receiver General. So that's it, Canada, that's the Dominion of Canada's internal bookkeeping,
yes.
not as between Upper Canada and Canada.
Yes, it had nothing to do with Ontario or Quebec or Upper Canada or Lower Canada. At this point, it was simply capitalized. And that then was intended by the by the auditor to eventually be added to the debt, which involved more than just this sum, that the old province, United Province of Canada, owed to Canada.
Thank you.
So in July of 1869, then, when you look at the accounts, just like the ones I showed you earlier, where you had the columns and rows showing the annuity funds and land funds and all of that. So what happened there now is the RHT and RSD accounts showed credits of $48,147 and $40,072. So there now you have, in addition to the small dollar amount that was still left over from a previous annuity, you now have this influx of cash, 48,000 and 40,000 in the RHT and RSD annuity funds respectively. And there was a notation in the 1869 book, which says, quote, "The total balances include the capitalization of the annuities," end quote. So this accounted for, quote, "the seemingly large increase of Indian funds," end quote. So that if anybody went through the books, there was an explanation as to why suddenly it was no longer 2,000 and 2,400, and instead 40,000 and 48,000. It was an enormous increase. It's because these annuities were now capitalized. And so the Receiver General's books made that clear, and also the books kept by Indian Affairs, which were a separate set. So this capitalization then basically put an end to this practice of drawing the annual annuities from the CRF and requiring a parliamentary vote. It obviated the need for that entirely.
And that was because, as you explained, the idea was that the interest would pay those annuities each year. Is that it?
Yes, and that's in fact what happened. Right.
And you mentioned that Langton had two proposals. One was the capitalization and the other that the amount be booked against the UPC's account. What happened with that? That second portion.
Yeah, you mean the second portion of the proposal, that it be
Well, when I look at your slide 55, you said that, I read the proposals being twofold. One, that it be capitalized at 88,000. And secondly, that it be charged against the old province of Canada as part of its pre-Confederation debt. And you've told us that in fact it was capitalized. Was it charged against the old province of Canada?
well, that became a matter of considerable dispute, which I outline at some length. So
Is that beginning at slide 58?
yes, so because of these jurisdictional complexities, well, first I should say that the Fathers of Confederation anticipated this problem. And so
And I'm sorry, Dr. Von Gerner, what is the problem?
Well,
that you're
the
identifying?
problem of the distribution of the debts and liabilities between Quebec and Ontario and between Quebec and Ontario and Canada. And so a lot of this is also an issue because upon Confederation, Indians, as the legal term was back then, the Indians who signed the treaties in the old Upper Canada were now under the Dominion of Canada's jurisdiction. This is the famous Section 9124. And so all matters relating to Indians were now under Canada's jurisdiction. However, the lands surrendered under the Robinson treaties, and any proceeds from them were largely under the control of the new provinces, more specifically the province of Ontario. And in this instance, in instances of the Robinson treaties. So, and that would be under Section 109 of the BNA 1867 Act.
And the BNA Act is what?
The British North America Act, which was our original constitution.
And then you mentioned that a year after Confederation, there was a new act that Canada passed. What
Yes.
is this one? What?
That was the making of, well, it had to do with a number of things, but among the most important for us here is that it made the Secretary of State of Canada the Superintendent General of Indian Affairs. So the whole structure of government was changed. And now William Spragg, who continued as the deputy, was now under the auspices of the Secretary of State, as opposed to earlier when he was closer to the Crown Lands Department, right? Of course, the Crown Lands Department is now no longer under Canada's jurisdiction, it's under provincial jurisdiction. And Ontario had its own Crown Lands Department, which was a successor to its portion of the United Province of Canada Crown Lands Department.
And then I think you describe here as well what the Department of the Secretary of State of Canada had the responsibility for.
Yeah, so it had the responsibility of anything to do with Indians and Indian reserves that had been set aside under treaties, but not for the territories that had been under which Indian title had been extinguished in the first place. Those, of course, would remain under the jurisdiction of the provinces, in this case, Ontario. And so, for example, the 1868 Act basically had the effect of tasking Canada with safeguarding the interests of those Robinson First Nations or Treaty First Nations, which had the additional post-treaty arrangements that we talked about, the disposition of reserve lands or timber on reserves and that sort of thing. And so they managed the monies that were held in trust under those arrangements. So the trust relationship between Canada and the Robinson First Nations was not just that they paid for the annuities, but also had to keep track of the proceeds from the sales of reserves, which of course are part of the land fund system.
Over on the next slide, you continue with some of the jurisdictional complications you identify. Can you take us through this one?
Yeah, so
Slide 59.
59. excuse
Thank
me,
you.
yes.
yeah, so Canada was responsible for ensuring that the Robinson Treaty annuitants as a whole continued to receive their treaty annuities. And, you know, the Indian books, or as we described them earlier, which were held by the Department of Indian Affairs, reflected that in the same way as they did prior to Confederation, in that they continued those ledgers with the annuity payments and distinguishable land fund payments.
That was like the example that you took us to this morning
Yes,
with the particular chief. Is that right?
yes. So now, when I say these are jurisdictional complications, now the most significant obstacle to fulfilling the Crown's duties under the Robinson treaties is, as I put it, the conditions under which the annuities were to be augmented required keeping track of revenues from lands no longer in control of the government that had inherited the treaty obligation. If that makes sense.
Can you break that down a little bit more?
So the conditions under which the annuities were to be augmented refer to proceeds from lands.
Required tracking revenues
Yes,
of lands that were no longer in control of, that were not in control of Canada.
correct. And yet Canada, under the BNA Act 1867, had exclusive responsibility over all matters relating to Indians. Therein lies the origins of much of the subsequent discourse in the late 19th century about who is really responsible for these various tasks.
And I believe the next section of chapter 4, you get into this with the arbitrations. Can I ask you to turn up slide 60? What are you describing here, Dr. Von Gernert?
Okay, so now we get into this business of, you know, who's responsible for paying debts, and it gets a little more complicated because, as I said, the fathers of Confederation anticipated that there will be disputes. And the way this was set up is under sections 111 and 112 of the BNA Act, Canada was responsible for paying the debts and liabilities of each province that existed at the time of the Union. But Ontario and Quebec were conjointly liable to Canada for any amount of debt exceeding $62,500,000. So because this gets a little complicated, it was anticipated that this would get to be disputed.
And that amount of debt that they had not going forward, but that they had when they were united.
Yes. So anything exceeding 62,500,000 was something that Canada considered Ontario and Quebec were conjointly liable to pay. So then, you know, you can imagine, you know, how do you reach 62,500,000? How much is there that goes over? How much of that is then split between Ontario and Quebec? There's all of these complications. And so in anticipation of these disputes, the BNA Act itself has a section 142 that was inserted to allow for an arbitration process
Can you tell us a little bit about that?
Well, it was basically a process that would allow 3 arbitrators, and one was chosen by Ontario, one by Quebec, and one by Canada, and then they would sit down and try and come to a resolution to whatever disputes arose as to who had what liabilities.
And I take it from the heading on this slide, the 1870 arbitration, that in fact happened?
Yes. It had, well, it's the proceedings started even before 1870, but an award was issued in 1870. So during these hearings that the arbitrators held, because the way it worked, it was Ontario would have not only appointed its own arbitrator, but it would also have its own counsel who would be before the entire arbitration. So there were arguments made by lawyers for Ontario and for Quebec and for Canada and before the arbitration committee. And during those arguments, I mean, I went through all of these, you know, this stuff. I should say, in fairness, that it was my understanding when I started this project that there would be other experts who would be opining on the whole arbitration part of this thing. So I went through this mainly so that I myself could understand it and be of some assistance. I have not read of any of these other reports. I don't know what they contain. This is my understanding of what this process was. So during the arbitration hearings, Quebec argued that it should not be compelled to share in the cost of the capitalization of the Robinson treaties, while Ontario denied any separate liability. And I think Quebec's argument was sort of based on the fact that, these lands are not in Quebec. Why should we have anything to do with this? Just because we were part of a joint United Province of Canada, why should we have any liability here? That was basically their argument. And Ontario denied it. So the arbitrators held, and I don't pretend to understand exactly what this means, but this was one of the things they held, quote, that all the lands in either of the said provinces of Ontario and Quebec, respectively, surrendered by the Indians in consideration of annuities to them granted, which said annuities are included in the debt of the late province of Canada, shall be the absolute property of the province in which the said lands are situate, free from any further claim upon or charge to the said provinces in which they are so situate by the other of the said provinces. So the reason I put this in is because this particular award by the arbitrators was then later revisited eventually by the Supreme Court of Canada in 1895. So that's mainly the reason I have it here, because it had a role to play later when the Supreme Court referred back to it as having been a binding decision.
And I understand you turned to that in another chapter, but within this one, you say for now, shortly after Confederation, and on slide 61, I understand you start speaking of certain memorials made by Robinson Huron chiefs. Can you tell us about that, please?
Yeah, so I'm doing this sort of chronologically. So at about the same time that this is going on, there was a memorial addressed to the Governor General of Canada, John Young at the time, sent by 13 RHT chiefs. We know it was prepared in June of 1869, but I found no record that it had actually been sent at that time. In fact, the document that is still extant in the archives has the signatures of 4 more chiefs who were added to the document on July 24th, 1870. So,
Can you tell me what you mean by memorial? A memorial? What is that exactly?
well, it's sort of like a petition, right? It's intended to memorialize their views to the Governor General. And because these memorials and petitions and pleadings of whatever description were written by or with the assistance of non-Indigenous people, they chose a number of different words to describe what these things are. So this memorial was addressed to the Governor General, and so if it's called a memorial, then I refer to them as memorialists. If it's called a petition, I refer to them as the petitioners. So the memorialists raised concerns about their fishing rights, and they also asked that the treaty's annuity diminution clause be waived, which I found to be an interesting request.
Do you know why that would have been made?
Well, they probably read it and thought, we don't, just because our population goes down, we don't want our annuities to go down as a consequence, because that's what the Robinson Treaty diminution clause stipulates. And they were not getting an awful lot of annuities. And one of the reasons they speculated may be why is that their population was decreasing, and which actually mathematically doesn't make that sense, but they feared that at some point in the future they would not receive even the little that was being paid by virtue of this clause. And they thought the Governor General would have the power to waive it.
Okay. And you suggest at bullet point 3 on slide 61 that there was some significance to some of the language in the memorial. Can you take us through that, please?
Yeah, so the memorial reiterated the annuity augmentation clause, but it omitted the final phrase, or such further sum as Her Majesty may be graciously pleased to order. And then they suggested that the practice of providing free grants of land to settlers meant that their ceded territory would produce no funds, allowing for this augmentation that they were supposed to get. And this is where this term reversionary interest comes in again. And this is only the second time. There's only 2 times this happens, and this is the second occasion. So they offered, quote, the surrender of the reversionary interest, end quote, and to, quote, execute a deed of surrender upon receiving reasonable compensation, end quote.
So this was the similar language that you took us to earlier today of Mr. Carney.
Mr. Carney, yes.
And you've just described to us that that the individual writing out the memorials often were not Anishinaabe people themselves. Do you know, was this Mr. Carney that wrote this again in this memorial?
I cannot determine that. I don't know whether whether these words are influenced by him. It may not be coincidental. It's the same kind of legal argument. I mean, what underpins, I think what's more important is what underpins this, and that is this belief that the lands are not providing the proceeds. Or you can imagine, the First Nations are asking the question, why are we not getting our augmentation? And the answer is, well, the lands are still not giving the proceeds to allow that to happen. And then they'd ask, well, why not? And then the answer is, well, there's no, the lands are not selling. And then, well, why aren't they selling? Well, some of them are given away for free. And I said, well, come on, if that's the case, how are we going to get any money? So then you get into some guy who's got legal training suggests, well, you have this kind of reversionary interest that, which has a monetary value, right? If you're not getting any, if you're not getting the money as you were promised because the lands are not producing any, then you could execute a deed of surrender of that interest for reasonable compensation. That is a legal argument that's obviously not an Anishinaabe derived approach to this. This is somebody who's, giving them advice.
Is there anything else on slide 61? I see that you also talk about the memorialists on slide 62.
Yeah, the only thing I wanted to add is that of course, it wasn't true that all the lands were being offered for free. There were other proceeds expected from mining and timber. It simply wasn't true that the lands were being given away for free. There were auctions. There was a modest income from mining and timber. So I'm not sure where this whole notion came from, but in any event, that was the memorial. So the memorialists believed that the Governor General could exercise what they refer to his kind interposition and cause an order for the waiver of the annuity diminution clause. They wanted the same sum of the original amount forever, even if the population dropped below. And if you do the math, it's 948 is the magic number, right? If it dropped below 948.
That's based on the clause in the treaty.
Yes.
And you also describe some things that you feel they didn't request. Can you take us through that?
So they requested this order for a waiver, but what they did not request, I found this interesting, that what they did not request was the Crown's kind interposition to augment the annuities and to cause an order to, to pay those augmentations. Instead, they basically implied that that entire clause could not be fulfilled in the first place because it was impossible to get proceeds from the lands. So then on July 25th, 1870, there was a second memorial that was signed by 24 chiefs from the North Shore of Lake Huron and the Great Manitoulin Island. It made no reference to the augmentation clause, but there's a host of other grievances.
Can you focus us a bit on what some of those might have been? Do you recall?
Yeah, I mean, there's fishing issues. There was a list of several, but none of them had anything to do with the Robinson Treaty Augmentation Clause. I gave the list in my report. I don't remember which footnote, but it's in there.
Might it be footnote 402?
Yeah, let's see.
Notice you list page 190, starting at page 196 of your report.
Yes. Yeah, so the grievances included allegations that the Indian Department often put pressure on them to surrender portions of their reserves, that statutes relating to game and fishery were making them liable to be punished, that they could not sell anything from their reserves without punishment, that some but not all clauses of the recent Act for the Gradual Enfranchisement of Indians were not suitable to them, and that the islands off the north shores of Georgian Bay and Lake Huron had not been properly surrendered. So
Okay,
those are
Roberta,
the
can I just
grievances.
stop you there for a moment? Your Honor, I noticed you flipping. Are you at the same page? Can I direct you?
I was looking for that footnote. Go ahead.
I believe it's page 196 and 197, Your Honor.
Thank you. And is it, did you say footnote 401?
402, Your Honor.
402, got it. Thank you.
So then over on the last slide of chapter 4, Dr. Von Gernert told us that there were these two memorials in July 1870. What became of them?
Okay, so these two memorials were placed before the visiting superintendent of Indian Affairs, William Plummer. So this requires a bit of explanation.
Please.
So you have the structure of Indian Affairs was basically you had the Superintendent General of Indian Affairs, who in this case was the Secretary of State. And then under him, you had the Deputy Superintendent General of Indian Affairs, who was William Spragg. And then under him, you had other Superintendent of Indian Affairs officials who were localized. So, and they were often referred to as visiting Superintendent of Indian Affairs or had some other titles. And Plummer was generally sort of the local Toronto office. Spragg, of course, was in Ottawa. Plummer was generally in Toronto. Sometimes he was at Manitowoc on Manitoulin Island.
But these are Dominion of Canada officials or new province of Ontario officials?
No, this is Dominion of Canada. Yeah, there was no Superintendent of Indian Affairs at the provincial level. So William Plummer would have been a subordinate to Spragg, who in turn would be a subordinate to the elected Superintendent General of Indian Affairs, who was also the Secretary of State.
And you told us in bullet point 1 that they were forwarded to Mr. Howe.
Yes, who is?
What happened next?
Yeah, so Howe, of course, is not Plummer's immediate superior, but it would have been forwarded through Spragg. And so Plummer had a covering letter, which I found quite interesting. Now recall that the Anishinaabe had not mentioned revenues such as timber dues in either of their memorials. But Plummer's covering letter apprised how, quote, "This question is frequently brought before me by the Indians and their friends who point to the revenue derived from the territory then ceded from timber dues and the sale of lands." So this almost contradicts what the actual memorials said. To me, what's going on here is clearly there are discussions, notwithstanding the memorial that claims that there are no proceeds from the lands and we have this reversionary interest. There have been discussions, according to Plummer, about proceeds that have been obtained from the lands, and they're bringing the question frequently before Plummer. Now,
You've
keep
just
in
told
mind,
us-
Plummer is the local Indian agent who is responsible for the RHT region, either out of Toronto or out of Manitowoc. And so he's getting, this reason why this falls on his desk, right? And he says, you know, that, according to him, he says, this question is frequently brought before me, and that, you know, they point to the revenue derived from the territory then ceded from timber dues and the sale of lands. So because of this covering letter, this whole notion of reversionary interest and all of that, that gets completely ignored. Rather, the Crown now understands that the claim is there are proceeds coming out of the lands, and the Crown should be looking into this because the Anishinaabe are claiming that the augmentation clause should have kicked in by now. That's how the Crown, from this point on, is interpreting the Anishinaabe claim, as opposed to the face of the memorial itself.
Wouldn't I thought you said earlier that all money from timber sales, that was from a reserve, or are we distinguishing now? These are timber revenues from the territory, not from the reserve.
Yes, that's what they are.
They're saying there are timber revenues
Yes,
from the territories.
they're talking about the territories that were surrendered under the Robinson treaties.
And why would the Anishinaabe have to tell the Crown about that?
Well, that's a good question. Absolutely.
The Crown would know that because they would be receiving those revenues.
Yes, although how would the Anishinaabe know it? It's only because of the rumor mill. And the rumor
Or
mill.
what
has-
they see, because they're local on the ground.
Yes, that's true. They see that their timber is being harvested, right? But at the same time, you know, they don't know any of the or the friends, as he says, the Indians and their friends, because
Well, that's what someone who wants to discredit the account. But if I'm just asking, if there are revenues, that would be information that the Crown had, better
exactly,
information.
exactly, and the Crown. Not as a consequence of this memorial, but as a consequence of the RST Fort William petition, acted on that.
Acted on.
Acted on the claim being that there should be proceeds now sufficient to meet the condition of the augmentation clause, right? But you're absolutely right. I mean, why was this initiated on the Anishinaabe side when the Crown, you know, is the one that's tracking the actual proceeds?
Well, I'm just looking at your evidence, which is what generated my question. You say the Crown now understands there are proceeds.
Well, no.
You're saying they only
no.
learned their proceeds from the Anishinaabe?
No, I don't think I testified that the Crown now understands that there are proceeds.
Oh.
The Crown now understands the claim. The claim according
Oh.
to Plummer, is that the point to revenue derived from the territory, from timber dues and the sale of lands. So what they see, as you correctly pointed out, they see harvesting happening within that territory, and they're wondering, well, doesn't this now meet the augmentation clause? And Plummer advises his superiors that that's what the issue is, and he's urging action on this issue because he keeps getting complaints about it. Nobody actually really knows whether the revenues are in fact such that it would allow for the augmentation, but it is presumed either by what they see with their eyes or what their so-called friends have been telling them. And that's a pattern that persists into the 1870s, 73, 75, it continues. And by now, of course, we're into the 1870s. So there are in the RHT territory, timber resources that are starting to accumulate revenues. So this is not a particularly surprising circumstance.
Okay. Thank you.
So you've told us then that Mr. Plummer forwarded the memorials to Mr. Howe.
Yes.
I think you deal with that in the last bullet. What happened then?
So Howe, of course, he's the Secretary of State and the Superintendent General of Indian Affairs, but he knows full well that under the BNA Act, he has no jurisdiction over these lands that have proceeds. He only has jurisdiction over Indian matters. So his course of action is to forward the two memorials to the Ontario Provincial Secretary. And the secretary responded that the issue would be considered by officials in his province. And then, so steps were taken. And at that point, I kind of lose the documentary record. I don't really know what happened after that. And we don't see any action on this until 1873.
And that's what you mentioned to Your Honor a moment ago.
Yes.
I know that you start talking about that at the beginning of chapter 5, and we're through chapter 4. I am quite content, Your Honor, to keep going, but if you or Dr. Von Gernert or the reporter or the court clerk would like a short break, that suits me fine as well.
Check with the boss. Break.
Sure.
Okay, thank you. We'll take a break now. 15.
All right. This court will recess for 15. This court will now resume. You may be seated.
Thank you, Your Honor. We're going to turn now to chapter 5, Dr. Von Gernert. It's one of your more lengthy chapters of your report. I think it's fair to say, and the slide deck is also. To orient everybody, I think, Your Honor, I hope to get through the first 2 sections of chapter 5.
Okay.
There was a question yesterday at the end of day about timing. Between my colleagues and I, we still believe that we will finish with Dr. Von Gernert on Friday, but we will certainly need the next couple of days. And then Mr. Schachter, I understand, was going to always start his cross on Monday. So we are still on time for that, notwithstanding the loss of this Monday.
Sounds great.
Okay.
Thank you.
So chapter 5 We're now skipping ahead. You entitle the chapter the 1875 annuity augmentation. And you begin this by talking about a petition by the Fort William Band. Can you just orient me, please? Who are they and what treaty are they a member of?
Well, Fort William Band is obviously treaty, the Robinson Superior Treaty, and are located in the vicinity of what's now Thunder Bay.
And so this petition is one now, you tell us, or you're going to tell us that they are bringing. The memorials that you spoke of before the break, they were which treaties, the two memorials,
They were from the RHT,
both of them?
yes.
Can you take us through this slide at 64, please, Dr. Von Gernert?
Yeah, so this whole chapter deals with the decision in 1875 to augment the annuities. And so much of the early part of this chapter is the lead up to that decision. And so it's titled the 1875 annuity augmentation, but it's actually about the period from 1873 to 1875. The fact is that this particular annuity, this particular petition is what prompted the government to act. So it's worth taking a look at. In February of that year, this petition was prepared. The only individual that seems to have assisted in the preparation of this petition, and even then, only marginally so, in that he acted as a translator, was Chauny, the Jesuit, who was the individual I referred to earlier. And there, in the record, we have two different translations. So this would have been, Chauny was trilingual, although his English was relatively poor. He was, of course, a Frenchman, but he had been living with the Anishinaabe for years, and so he was fluent in Anishinaabe. And so there are two extant translations, and the second one, according to Chauny himself, is purportedly the most literal one.
Can you take us through that?
Yeah, so there are only two sentences involved here. So the first translation is, reason enough there is already, I think, that you should give me what you promised. $4, bracket, condition of the treaty, end bracket. Those $4 were to be first got to be paid to me from that land which contains in its vast extent such great riches. And the more literal translation, according to Chauny, was, there is enough already that thou canst give me what thou hast promised to me, $4. The condition for $4 is that this, my payment, should at first come forth from that great land, greatly rich. So I should just say in passing, and I say this again elsewhere in my report, that this to me suggests that, the Anishinaabe at Fort William were, they understood that their treaty augmentation to $4 would come from the proceeds of the lands, which they considered by now to be rich. They say, there is enough already that thou canst give me. So, I guess in common English, that's, that the lands have produced sufficient income to provide us with the $4 annuity.
And do you know what they were referring to when they said greatly rich, the land with greatly rich?
Well, they had always understood that their lands were rich in mineral wealth because that's how this whole Robinson Treaty process got started. It was, based on the view that it had, as Shingmakon said early on, he saw men with hammers coming in. He wanted a share of that, so he knew about the minerals that they could see the miners prior to the treaty. So this is just an extension of that. So the petition alleged that by now there were sufficient proceeds from the lands to warrant the increase in the annuity to the promised $4 per capita. Now the great riches that were specified in the words of the first translation, or land greatly rich in the second, was more specifically referencing probably the Silver Islet mine that was located right near Fort William. I don't know if you know that area of Thunder Bay, but there's a sleeping giant park, and there was a mine there that was established. There had been rumors of silver there for quite some time, and eventually a mine was established there. And then, as we'll see, Boron later, who had been the inspector there, wrote extensively about its progress.
Bless you.
Thank you. Shonay?
Shonay, the same one that I discussed earlier, CHON.
E.
with
Exantegu.
E accent aigu.
And then I think you told us earlier that, or let me ask you a question. Is there a difference in your mind between a petition and a memorial?
No, I mean, these are all communications that are being forwarded to governments on behalf of Anishinaabe peoples. Some are more literal than others. Some are, couched more in the language of the person who forwards the petitions. But for the most part, petitions or memorials are the same things.
So then on slide 65, can you describe to us, please, can you take us through this slide and describe to us, please, what happened to the RST 1873 Fort William petition?
Yeah, so now we have Simon Dawson coming into the picture, and he's a really interesting character.
Who was Mr. Dawson?
Simon Dawson was originally trained as an engineer. He worked as a surveyor and as an engineer in the public works section of the. Well, I should backtrack it. Back in the 1850s, he was an early. He participated in the early exploration of the lands to the west of Fort William.
That's,
So
are you
to the
now
west of
talking Treaty Three
Thunder
area?
Bay, yes. So beyond the Haida land and all the way to the Red River settlement in what is now Manitoba. So because the government was contemplating making closer connections between Upper Canada and the Red River settlements. So by the 1860s, Dawson had been placed in charge of building an actual road from what is now Thunder Bay all the way to the Lake of the Woods. And it was anticipated that it would continue all the way to the Red River settlement. When I say build a road, we're talking about a combination of sort of rudimentary corduroy type road with some water passage wherever it was possible. And so he, in the course of doing that, was very closely associated with various Anishinaabe groups, and he knew them very well. Some of them worked with him as his employees. He hired Anishinaabe peoples, and he used them as guides and as workers. And there was all kinds of contact between him and Anishinaabe people. And so he became very, I would say, exceptionally sympathetic to their interests. And that's revealed throughout the history of his public service. And so by the time of this particular petition, he had already been appointed by the Crown, by the Canadian Dominion, to be a treaty commissioner for what was supposed to be treaty number 1, but which eventually became treaty number 3. So as treaty commissioner, he again had considerable exposure to Indigenous peoples, most particularly Anishinaabe peoples. And he, because of his intimate knowledge of the region and his close association, he was given this role. And at the time when this petition was forwarded by him, he actually still had involvement in the Treaty 3 business. He had originally been one of the commissioners going back to 1871 when they first started negotiations, and he was still there in 1872, and he was still there in 1873, except that the lead commissioner was now Alexander Morris, who ultimately was responsible as the lead negotiator for Canada on Treaty number 3. So in the course of his work, Dawson's work, before Morris came, Dawson was one of the commissioners who sat down with the Anishinaabe and began negotiations, which ended in failure several times, first in 1871 and then again in 1872. Partly because the government offered a $3 annuity, which was unacceptable to the Anishinaabe. And Dawson, he was never too concerned about the public purse, so he lobbied, to have it made $10, to make the offer $10. But the government thought it's not going to happen. It's just way too steep. And so eventually, that same year that this petition from Fort William came out, the parties eventually agreed to Treaty number 3, which included a provision for a $5 per capita annuity. So that's sort of the context of all of this. Treaty 3 had not yet been signed, but the negotiations had already been going on for years, and Dawson was involved.
And then you say that he also prepared, similar to, I think you said, Plummer, with the earlier memorials. Mr. Dawson prepared a covering letter. Can you tell us about that?
Yes. So this is now a new Governor General, right? As I said in the previous slide, it's now Lord Dufferin. And so Dawson thinks, well, if I send this petition, which is, the wording may in and of itself may not really be comprehended by the new governor, and certainly the context in which it's sent and the reason why it's sent may not be perfectly comprehensible to the governor. So Dawson decides to send an explanation as a covering letter. And this explanation was more a lengthy pleading on their behalf rather than an explanation. He called it an explanation, but when you read the letter, it's a passionate pleading that something be done.
Is that what you describe at the next slide?
Just before we get there, you said with respect to Mr. Dawson, you said never too concerned about the public purse. Is that
Yeah.
an editorial comment or?
It's just my experience with his extensive communications with the government. He would often lobby for more money,
For the Anishinaabe?
not only for Anishinaabe, but for public works, for his project, building a road from.
And you conclude therefore he's not concerned about the public purse as opposed to he has other priorities or concerns.
No, I conclude from his correspondence that he was, because he would suggest that, an exorbitant amount of money, and then you get immediate response saying, no, that's not feasible. So he would highball it and in the hopes that to get as much as possible, whether it's the.
In the hopes of achieving some goal that he thought was
Yes.
worthy of the public service.
Yes, exactly. But, the government had its limits, obviously, and it's like any, public official, even today, they're going to lobby those with the purse strings to get as much as possible for their cause.
Because they're interested in their cause as opposed to they're not interested in the public purse.
Yeah, I mean, I think Dawson knew that a $10 annuity was not going to happen, but he lobbied for it anyway. Because he felt that, that would be a fair amount. What I should say is this: he didn't actually lobby for $10. That's actually incorrect.
This is
What he-
with respect to Treaty 3.
Yes, what he lobbied for was to give the treaty commissioners, including himself, the discretion
Mhm.
to offer as much as $10, which is it's a nuance difference, but it's right.
Not an unusual request for a
Yes.
negotiator.
Yes, that would be fair. Yes. Because he wanted success, obviously, and
Mhm.
there's no better way to succeed than to have the ability to offer as much as you can.
Okay, thank you.
Slide 66. You were going to tell us about his covering letter, I believe.
Okay, so Dawson's covering letter claimed that an annuity increase was warranted, quote, of at least $4, if not of such further sum over and above the $4 as Her Majesty may be graciously pleased to order. So this interpretation of the treaty clause, as we'll see throughout this entire literature, was actually not the prevailing one that Crown actors had at the time. And it's not the interpretation that Dawson himself advanced later when he became a federal member of parliament for the Algoma district. And at that time in 1879, we're just sort of getting ahead of ourselves a little. He just said in the House of Commons when he was passionately trying to get the arrears issue settled. He said the treaty contained a clause by which the government became bound to increase the annuities to $4 per head as soon as the revenues arising from the land ceded should amount to a sum sufficient to admit of this being done without loss. And that was more in line with what Crown actors of the period understood. So, but at this time in 1873, he worded it the way that he did as in my bullet point 1. Now, the Dawson alleged that the RST annuities had since 1850 been receiving only about $1.50 per capita, which wasn't actually true because I've looked at the actual records, and
What were they receiving?
well, they received varying amounts. So sometimes, you know, in some years it was $1.70 or more. In other reasons, it's more along sort of the 160 in that range. But by Dawson's time, it's true, they were only receiving closer to, maybe it's his wording that gives a false impression. Because by the time that he's writing, you know, it had been lower. But he made it sound like, you know, that since 1850, they'd been receiving only about 150. In any event, that's nothing to do with his actual point. His point is that they were receiving a very modest amount, a very low amount. And I think that was universally understood. Everyone, you know, thought they were receiving way too little. But he wanted to emphasize that they should be getting their $4. And to emphasize that, he engaged in what might be described as sort of rhetorical exaggerations.
Is this what you discuss at slide 67, Doctor?
Yes.
If you can take us through what you have on the slide.
Yeah, so he argued that the annuity was too small and that the Anishinaabe claim was sustained by the augmentation clause, and it should have been triggered by now because considerable sums were being realized from the lands. And so he asserted that over the last 2 years alone, 1871 and 1872, probably $1 million or more, he claimed, had been realized in timber berths and lands from the treaty territory. And then he said one mine alone yielded about $100,000 per month.
Now, was Dawson a public servant at this point? What was he doing again?
Well, he was a public servant, yes. He was still, you know, an engineer, although he had been also at the same time, he worked for the Public Works Department, but he was also, as I said, assigned as a treaty commissioner. As far as I know, he really didn't know, he wasn't intimately involved in the Crown lands side of things because that was Ontario, right? This is now 1873.
So where would his figures have come from? Do you know?
I have no idea where his figures come from. I just know they're wrong.
How do you know they're wrong?
Well, because you know, if he had consulted the publicly accessible annual reports of the Crown Land Department, then he would have realized that they were wrong. I think what he did is he just did estimates based on what he thought was going on. He had eyes too. He saw, you know, the proceeds because he was on the ground too, much as the Anishinaabe, as Your Honor said earlier today. He was on the ground as well and saw, but he did not derive these from any figures that were publicly accessible, as far as I know, because we have those figures and they're nowhere near these amounts. So these were exaggerations, obviously, for the purposes of impressing upon the Governor General that something needed to be done. And in fairness, you know, that such a rhetorical flourish is quite effective. And he may still have been correct in his point that, the augmentations should have been sufficient to
Or
ensure.
the revenues should have been
I'm
sufficient.
sorry, I stand to be corrected. The revenue should have been sufficient for the augmentations.
And did he make a recommendation?
Yeah, so not only did he say that, these revenues were on the rise, but he also recommended retroactive annuity increases to at least the time of Confederation. He gave no factual justification for it, but that was his recommendation.
And then what happened to that recommendation? What happened next?
Well, unlike, the earlier memorial that I talked about 2 years earlier, which I found no record of a response other than that it was communicated up the chain and then across to Ontario. In this case, this happened at an incredible speed, like nothing I've ever seen. Even by today's standards, this was very swift action.
Can you describe what you mean by that? What happened exactly?
Okay, so Dawson's letter of April 7th goes to Lord Dufferin, who's the Governor General. He immediately, like within this, probably at the very time that he received it, which would have been just a few days later, he encouraged officials to look into the matter, and his opinion was, quote, that it will be advisable to ascertain whether the petitioners are not entitled to claim an increase of their annuity in accordance with the term of the treaty, end quote. So he's not recommending an augmentation, but he's forcefully encouraging the government to consider it, because he can't sort of say, you better augment this, right? Because he doesn't have the facts. He's only got Dawson's assertions that this is true. So, but he wants action immediately.
So I believe we're now on slide 68, and what you just quoted from is the first bullet there. Can you
Yes.
take us through the rest of that slide?
So the government acted literally within days of receiving this notice. And the file landed on the desk of Deputy Superintendent General of Indian Affairs, William Spragg, who I introduced you to already. He's the top civil servant in the Dominion government, mandated to deal with Indian affairs. And this was an Indian affair.
And what did Deputy Sprague do?
So he acted on it immediately. He searched the records. He went through extensive mathematical calculations. He prepared an exquisitely detailed memorandum that surprises me to this day. And this was already by April 13th. So between the time the government received the petition and the time that there was a detailed memorandum on the matter from Indian Affairs was, a matter of less than a week.
And I take it you've reviewed Sprague's memo then? Can you tell us about it?
Yes, this is, Your Honor, that memo is really worth reading in full, because it illustrates how complex this task was. We think at first blush, this should be an easy thing. You calculate the proceeds, get to the net proceeds. You've got your proceeds and costs, you get the net. You then sort of figure out how much each person would be owed or how much the augmentation should be, and then you start distributing. It's not that simple. It never was. And
You offer, I think, a summary of that memo, beginning at the last bullet of page 68 of slide 68.
Mr. Schachter's on his feet.
Yeah, just for the point of clarification, and I don't, not sure if we're gonna get to it, but it's not in the slide deck. There are two sprayed memos. We should be clear which one we're talking about. And if there's a difference, the witness will probably direct us to the differences, but I just want to know which sprayed memo we're talking about.
Is it
Okay.
dated April 13th, did you say?
yeah, so at pages 221 of my report,
221?
okay, so one of the excerpts that I suggested reading was on page 221 to 222. And so the footnote there is 457. And so that's a memorandum of April 13th, 1873, which is at the bottom of page 222 of my report at footnote 457.
Does that help, Mr. Schechter?
If that's the one you want to refer to, that's fine. Thank you.
Go ahead, Dr. Von Gernert. I believe you were going to start summarizing.
So Sprague acknowledged that the Anishinaabe had, quote, from time to time, end quote, complained that their 2,000 and 2,400 annuities. So we're talking about the RST and the RHT annuities
Respectively.
had not been augmented, notwithstanding considerable proceeds. So Sprague seems to have acknowledged that it wasn't just this particular petition sent by covering letter by Dawson, but rather he had heard from time to time. And of course, as we saw earlier, there was that occasion in 1871, the earlier one from the RHT.
The two memorials you spoke of.
Yes. So Sprague knows that this is an issue, and he now looks at it in great detail because he's received, this file with an instruction from the Governor General himself to look into this and ensure that action is taken.
And you continue on the top of slide 69. I think you just flipped to.
Yeah, so this is something that, I emphasize throughout my report. Sprague understands the Robinson treaties much as most other Crown actors during the 19th century. And that is that the pre-augmented annuities, in the case of the RST, the $2,000, was augmentable to a maximum that would allow payments of $4 per capita. That was the understanding. So you take the 2,000 and you increase it until it's sufficient to allow payments of $4 per capita. Now, to determine if the government was now positioned to do this, you first needed to know the difference between the pre-augmented annuity that was already being paid and the $4 maximum annuity.
Wouldn't that be just a matter of simple math?
Well, it would be, except that the population fluctuates over time and from year to year. And so this became a huge issue. And as I noted on those pages, I just referred to pages 221 to 222 of my report. He did an extensive analysis of this issue, which is surprisingly complex. And he felt the best way to finance the difference between the pre-augmented and the augmented annuities was to establish an interest-bearing capital sum, much like those that were already in place in the RST and RHT annuity fund accounts. Remember that those were capitalized in 1869 after the Auditor Langton had suggested it. So Sprague felt that, you know, this would be the best way to do it. And so he came up with this solution, which I give on the next slide.
Slide 70.
Yes.
Okay, so walk us through this. What is this?
All right, so this is his solution to how to do the annuity augmentation financing.
This is slide 70.
Yes.
Thank you.
And to be clear, this is you translating it, or this is from a historical
Yes.
document?
When you take the analysis he did, which is shown on pages 221 to 222 of my report, and you look at his lengthy memo, this sort of summarizes the solution, because it's much more detailed in the memo, but this is,
Just to follow up on Ms. Barclay's question, this is your chart as a
Yes.
summary of what he wrote.
yes.
Okay, thank you.
So can you take us through this with respect to the RST in particular?
Yeah, so Sprague looked at the time of treaty population, and there are reasons why he decided to use the time of treaty population. The first reason, as he himself went to great lengths to describe, is that there were enormous fluctuations in the populations as a consequence of, among other things, in migration of large groups or out migration. And so these fluctuations just made it impossible to sort of give an average where, you know, the extremes were close to that average, right? It was just these fluctuations was way too high. So he thought, you know, since Robinson had already given a population figure in the treaty itself, which was in line with the practice at the time, all of those, remember all of those pre-1850 treaties, they also had population figures. Robinson had included those specifically for the purposes of the annuity diminution clause. That's why the population figures are in there. So they're already connected to the annuities. So Sprague says, well, if they're being used for the annuity diminution clause, then why not use them for the purposes of calculating the augmentation as well? That was the logic behind it. And that would obviate the problems or be a solution to the problem of continuous fluctuations in population. The idea here, once again, is that to arrive at the best possible solution to the augmentation, capitalization is the form that it should take, because then if you calculate the difference between the per capita annuity and the increase that's required to augment it to the total, you arrive at a figure that you can capitalize, and it'll be one figure. You
And
don't
when
want
you
to,
say between the per capita, you're talking about the third column, the 1873 per capita.
yes, so I should explain what each of these columns are. So you have the time of treaty population of 1,240. Then you have the per capita annuity, which Dawson was pretty close. Remember, he said it was about $1.50, although he suggested that's something they've always been getting. But But in 1873, they were getting about 150, right? And so the difference between that and what was required to reach the $4 cap was $2.50.50. Right? So if
That's assuming, that's taking the time of treaty population.
yes, so you take the time of treaty population, and that's how you calculate how much of an additional capital sum you need on top of the one that's already extant. Remember, there's one already, Robinson Superior Treaty already has a line in the books for the original capitalization of the fixed amount of pre-augmented annuity.
That was what you took us through with John Langton's numbers.
Yes. Now, in additional to that, you need another capital sum, which at 6% would be 51,770, or if you calculate it at 5%, it would be 62,124. Now, he gives reasons on page 222 of my report. He gives a rationale for giving two different percentages.
And I think you go through this at slide 71.
No, I don't, but I do give his rationale for the two different percentages on page 222 of my report,
Okay.
where he actually says, in the last paragraph of the quotation on page 222 of my report,
Maybe we can just pause there for a second, Dr. Bungren, and we can pull that up for everybody's use. This is the excerpt you took us to earlier in response to Mr. Schachter's question about the memo, I believe.
yes.
Page 221. There we go.
Page 222. Right, so the last paragraph of the quotation that you see on the screen. So the difference between an annuity of 149.5 as recently paid, so those are the RST annuitants, and $4 per head will be 3,106.20, and which at 6% represents a capital of 51,770. Or at 5%, being the rate of interest allowed by the government on deposits of Indian money, will represent a capital of 62,124. But as by far the larger portion of the principal must be derived from funds obtained from the Ontario government, realized from sales of land and timber, it would rest with the Dominion government to either to increase the interest on Indian monies from 5 to 6%, or to make an equivalent arrangement. So that's why he's given us his scenario as two different possibilities based on two different interest rates. So as you can see by his comments, he is of the view that A, there is an upper limit to the augmentation. B, it can be capitalized based on the time of treaty population. And C, he thinks that the monies should come from Ontario, because they have the proceeds.
And is he making a judgment, an assessment, it can be capitalized or it should be capitalized?
his recommendation is that it be capitalized.
Right.
And his recommendations were usually followed then by,
But I just was distinguishing,
Yes.
it can or it should be. Like, he's not commenting on what's in the bank.
no,
somewhere.
no, not at all. No,
Okay, got it.
he's recommending the adoption of this scenario
Got it.
as a solution.
Dr. Von Grunet, I thought you had moved to slide 71 a moment ago, but you corrected me. Are you still on slide 70 or are we now moving to slide 71?
71, I believe.
Okay.
I'm just looking at the clock, Ms. Barclay. How does this fit?
Just
with
was
your-
noticing that myself. I thought we might get through this section. There's 3 more slides, but it's taking a little bit longer than I thought. Should we go on or should we change? And why don't we stand down if that's suitable to your honor?
Thank you. We'll break for the day then. Thank you.
Thank you, your honor.
And until 10 tomorrow.
All done? Oh yay, oh yay, oh yay. The settings of this court have now concluded. Long live the king.